the Constitution. You just hold that up and it stops bullets and fire and terrorists and everything.
Pure fucking nonsense.
I don't know if you've answered this, Gary, specifically, but I'm still going to search for it unless I hear a relevant response. What's the purpose of filing an interlocutory appeal when there has been no decision made?
An interlocutory appeal when there's been no decision made. An interlocutory appeal is about an action that is before the final conclusion. So what decision are you referring to, I guess, is kind of the question.
Well, the context that it was used in was is the information in both the appeals that you would fire afterwards or the interlocutory appeal, would the information be the same?
So let's say I say objection for blah, 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 and here's my objection, here's the reason I object, and I move to strike, whatever. Okay? Judge says denied. That is a decision, right?
Mm-hmm.
Now, so a decision is being made constantly. So you're saying that is before or that is after a decision's been made. Now, an interlocutory appeal is between that decision and the leveraging of that decision to the next stage.
Oh.
So an interlocutory appeal is of not the final decision, the overall conclusion, but rather of the intermediate decision of I'm denying your motion to, I don't know, let's say this. Let's say they want to bring your ex-wife who hates your guts to the stand in a trial, okay? She has no fucking thing to give other than testifying that you are a Satan worshiper, okay? Now, you do a voir dire. They send the jury out. You're there doing a voir dire saying, do you have any testimony to offer other than my religion? And she says, nope, that's enough. That's all I'm here for. Prosecutor told me to come. Tell this good jury that you're a dirty, no good devil worshiper, whatever the hell, right? And you go to the judge and you say, objection, I move that this witness be precluded for having no relevant testimony to offer, but instead only having inflammatory statements to offer in an attempt to create a bias against it. The judge says, I'll allow it anyways. Okay? Now here's the crux of it. This is something that has a material effect upon the course of everything. Right? Everything changes. It's not just a mundane little detail. It is the heart. I mean, it becomes a huge issue where her not testifying, everything goes very differently than her testifying. So this is a very clear case where an interlocutory appeal is appropriate because it needs to be addressed now. It can't be repaired later. It's not something you can take to appeal and say, well, I'm appealing this based upon the idea that the testimony was a violation of due process. They'll say, well, now you need to prove that the jury would have ruled otherwise if not for that devil worship thing. So the interlocutory appeal is there to mend mistakes that cannot be corrected after the fact, after the finality.
As if the judge were to be taking judicial notice of jurisdiction that they have.
Right.
Okay.
Right. That cannot be fixed because the manner in which things proceed is very different because you're missing the information that underlines that. Okay. So let's kind of make it a little bit, oddly enough, more clear. So let's say you're saying, let's say they haul you into court and they say, you know what, I'm not going to read you the charges. I'm just going to rule that you know them. I hereby make a ruling that you already know the charges. Okay? Now, your problem is, you're like, well, that's interesting, but the problem is you're acting as if I know the charges, but I'm actually missing that information. Okay? So I have no means by which to actually proceed. And the manner in which I proceed is going to be random by necessity, because I'm missing a piece of information you're proclaiming, you're pretending I have.
Okay.
Now, an interlocutory appeal would be appropriate because I can't appeal the whole ordeal. You know, the trial goes down and it all looks fine. It's like, well, we don't see any problem. They presented their case and you didn't have much of a defense, and by George. But the interlocutory appeal is about the fact that I was forced to proceed in ignorance by this error. And in that ignorance, I sabotaged myself. Let's say that you get a few steps into it, right? Let's say he says, I hereby rule that you've been informed and you know this stuff, and that you're just playing games like you don't. Okay, you get a few. You're trying to defend yourself. You're sat into court. They're putting up their arguments, and you're missing great points that you could object on, move to strike, but you don't know what you're actually accused of, so it's a little bit random, right? And then later on, he goes, "Hey, you know what? Here's a piece of paper with your charges on them, by the way." And now you discover what the hell's going on. And you make it through the rest of the trial and so forth. The problem is, all these admissions that were in the meantime made things impossible to correct. So it's not something that can be fixed by sending it back down to a lower court for whatever. I mean, and so it's not something that can be fixed by appeal. It's a fundamental error.
So where do you file this interlocutory appeal with? The court that you're having the issue with, or do you go with the higher court?
I would tend to say the higher court, but I would ask that clerk. Well, again, you might be mentioning as it's happening, you might say, this is an issue that really, really needs an interlocutory appeal. I have every intent to immediately file a motion. And in fact, even trying to proceed before that's been ruled upon will drastically harm these proceedings and my rights in these proceedings. What, Judgy, is the process by which we right now address my problem?
You make it sound so severe.
It is. It's shocking. Things that are completely mundane, normal things in court are shocking. I mean, one of the best examples I have is a guy was representing himself, quote unquote, defending himself, whatever you call it, and he had a standby counsel, right, who was a nobody. I mean, this was the weakest of possible standby counsels. It was one of those, I tell you what, we'll decide if she's even a standby counsel later. You know, we're just going to have her stand there and be aware of things in case she needs to come in and something go on. That lawyer and the prosecutor went up and had a conversation with the judge mid-case. That is called ex parte communication about a case during a trial in front of you. And they act like it's no big deal. They do it every day. They don't even think about it. It was done to me. I was left out. That's called ex parte. That's highly, highly improper. But they do it all the time, right? So all this shit that they do all the time is completely, if you call them out on it, suddenly they're screwed in a lot of sense, in a lot of instances. So double jeopardy is supposedly one of the big bad ones, right? Never supposed to happen. I bet we could find tons of cases where it had been done. All you got to do is go through any time that there was a mistrial and find the ones where the defendant wasn't the reason that was mistrial. And that technically is a double jeopardy. And you could argue it. And I bet tons of those would be, oh, yeah, they were convicted the second time around and don't even know that there was that is supposedly against their rules. But defense attorneys, all them attorneys are like, oh, yeah, they do that all the time, so it must be okay. Right?